A week or so, 10 days ago, I talked about the Turkish lady in an American university, Rümeysa Öztürk, and um, and how she was arrested in the university campus by masked um, authority figures as she was on her way to celebrate iftar. And today I want to speak about this deceptively bureaucratic yet human case, the arbitrary erosion of due process under the guise of national security, seen starkly in not one case but in two cases, Rümeysa Öztürk and Kilmar Abrego Garcia. So, beginning with Rümeysa, this Turkish doctoral student at Tufts University in Massachusetts. Rümeysa Öztürk is not a flight risk, she's not a criminal. She's a Fulbright scholar in child development who co-authored a student article calling for Tufts to divest from firms that link to Israel, a peaceful act of protest and not particularly original. Yet on a quiet street in Somerville, she was ambushed by masked ICE agents, shackled, denied food during Ramadan, and shuttled through 4 states without access to her lawyer or medication. She suffered 4 asthma attacks and had her hijab forcibly removed. And why? The Department of Homeland Security accused her vaguely of supporting Hamas, although the State Department has now found no evidence of anti-Semitism, of terrorism, of any violation of visa conditions. She was targeted for speaking, not for plotting, for writing, not for waging war. She was targeted because she was a victim of racial discrimination. She was targeted because she was a victim of racial profiling. And even now, DHS insists it can revoke her visa in silence, using broad discretionary powers under the Immigration and Nationality Act, bypassing evidence, transparency, and moral accountability. In other words, the government has admitted it cannot prove wrongdoing, yet it intends to deport her anyway. And Öztürk is not alone. The tragic case of Kilmar Abrego Garcia, a Maryland man deported illegally to a maximum security prison in El Salvador, and this despite the fact that he had he had withholding of removal status, which explicitly prohibits and protects individuals from being sent to countries where their lives would be endangered. And the government acknowledged this deportation was an administrative error, and yet it refuses to bring him back, even when the Supreme Court itself directed officials to explain what steps were being taken to reverse the mistake. Why? Because readmitting him would embarrass the administration. It would force them to reveal the flimsy justification for branding him a gang member based on anonymous informants and the fact that he once wore a Chicago Bulls hoodie. Notably, he is married to a US citizen and raising a child with autism. What unites the two cases is not merely government overreach, it's the deliberate use of immigration law as a political weapon, targeting individuals not for what they have done, but for who they are, what they represent, or what they may have said. In Rümeysa's case, she represents a political inconvenience, a Muslim woman with a pen and a conscience. In Abrego Garcia's case, he represents a vulnerable scapegoat and undocumented immigrant easily labelled and discarded. The Trump administration's position in both cases is that the courts have no jurisdiction, that discretion equals impunity. In Öztürk's case, the government argue that the courts cannot question a visa revocation. In Abrego Garcia's, they say they are not obliged to correct an admitted illegality. But if that is true, then we are no longer living under the rule of law. We're living under the rule of exception, and where America has trod, Britain will follow fast. Governments have the right to protect their borders, of course, but protection is not persecution, and discretion must be tethered to evidence. And national security must not become a euphemism for silencing dissent, criminalising speech, or deporting people based on politics and prejudice. Both Öztürk and Abrego Garcia deserve what every person in a democratic society should expect: due process, transparency, the right to challenge the government's actions in a court of law. What we are seeing in Trump's America is a creeping authoritarianism in immigration enforcement, masked agents without warrants, silent revocations, secret memos, administrative errors that land people in foreign prisons or locked cages. And we shouldn't forget, Öztürk was arrested for co-authoring a university editorial. That alone should chill the spine of anyone who believes in academic freedom. She was branded a threat because she asked her university to reconsider its investments. Imagine being deported for writing in your student newspaper. And Kilmar? He was deported despite a court order. He was tossed into a Salvadorian prison despite clear legal protections. He was, quite literally, disappeared by his own government. And what does this say of our legal system if a court cannot stop the state from making such disappearances, from conniving in illegality? These aren't isolated stories. They are symptoms of a broken immigration regime twisted into an ideological machine less interested in law than in vengeance. Where Trump treads today, the British Home Office will tread tomorrow. The American Immigration Council said the one thing the government has to do is to give him due process. It hasn't. Not to Kilmar, not to Rümeysa. These are just two people. But this is not just about two people. This is about whether America first and then Britain should allow fear to eclipse fairness and discretion to replace democracy. If we allow governments to act without scrutiny in these cases, then no one is truly safe. Not students, not immigrants, not citizens. We must demand transparency. We must insist on the rule of law. And we must never accept silence in place of justice, or convenience in place of law, or evil and tyranny in place of due process.